Good afternoon, everyone. Welcome to an introduction to family mediation for members of the local Family Justice Board. I'm Helen Anthony. I'm the Chief Executive of the Family Mediation Council. I'm very pleased to be joined today by Romina Kamran, who is a Family Mediation Council accredited mediator. Apologies to those of you who are hoping to see Jan Coulton. Jan's unwell today and therefore unable to join us. However, Romina has very kindly stepped in and will be happy to help with the presentation and answer your questions at the end. So we're here today to talk about what is family mediation and what are the benefits to families of coming, and then we'll talk a little bit about the practicalities of family mediation as well and how you can signpost clients to that. Family mediation is a process in which those involved in family relationship breakdown or change appoint a third person, a mediator, to assist them to communicate better with one another and reach their own agreed and informed decisions. So the mediator is impartial, and the mediator is not making decisions for the participants are making those decisions themselves. Mediation is voluntary, mediation is confidential with certain safeguarding exceptions. The mediator is impartial, as I've already mentioned, and the participants are not the mediator to determine the outcome. Those are some of the key principles. Family mediation is for families of all different shapes and sizes. It can be for ex-partners following separation or divorced. It can be for parents who have never lived together. It can be for extended family members. It can be for blended families. And those family members could be talking about financial issues. They could be talking about arrangements for children. They might be talking about issues that can be resolved by the court, and they might be talking about issues that a court wouldn't resolve. Romina, do you want to give some examples of cases that you have covered recently?
Of course, thank you. I think the key thing to remember is that mediation isn't one model. It's flexible as a process and it's ultimately shaped by the families. And you mentioned different examples. So I had a joint mediation not so long ago. It was a parenting children's arrangements case. And the two parents, they'd separated amicably. But over time, as is quite common, communication had deteriorated. And so they came to mediation and it helped them move from reactive messages to, challenging communication to a structured approach. Most people have never done this before. They don't know how to approach the fact that they're no longer together, but obviously looking after their children. So mediation can lay out a very clear parenting plan that they can adhere to. It can look at holidays, it can look at boundaries, just lots of things that generally parents wouldn't be thinking about otherwise as they're navigating the sort of separation and divorce. And so it was quite helpful. In shuttle mediation, which for those of you that don't know what shuttle is, it's where it's not appropriate for clients to be in the same room, either face to face or if it's virtually online. This can be really, really helpful in high conflict cases. They're unable to sit in the same room. I had one again not so long ago. And as a mediator, you wonder they're going to make any progress at all. But of course, that separation, then being able to talk to someone who's completely neutral, which is what we are as mediators, we're not there to give opinions or advice. It meant that they could go through the process in a way that felt comfortable and secure, reduce the conflict, and it resulted in them being able to then agree. After about 4 sessions, we got to on a very structured kind of arrangement for their children. And similarly, it works really well with financial mediation as well. So, very complex financial case that I had was a very long marriage with pensions, property, a very unequal earning capacity. But mediation really helped them kind of phase the different parts that they needed to focus on. So disclosure, we took our time, making sure both parties were at the same pace in terms of understanding why we were disclosing, why it was important, what was the end goal. We prioritized housing for the children and we were able to then narrow the issues before they sought legal advice. So mediation adapts conflict levels and complexities and supports clients to generally a much healthier way of reaching an agreement.
Thank you. And I think one of the things that I picked out of that, which I didn't mention already, is that mediation meets clients where they're at.
Mm.
So that they can come in at any point in their relationship or following their relationship. And it's very flexible to meet their needs and address the issues that's relevant to that particular family.
Yeah,
Thank
absolutely.
you. Um, so we're going to talk a little bit now about who are the mediators. So Ramina is one of the about 1,050 mediators we have on the FMC register. All mediators on the FMC register have done approved training. They follow a code of practice. They do continuing professional development. And we have professional practice consultants who act as supervisors and mentors to other mediators. All mediators on the register have to have insurance and they offer access to a complaints process if things go wrong. Um, Mediators, after they pass their training course, they compile a portfolio of work and submit that for accreditation. Only Family Mediation Council accredited or FMCA mediators are authorised for the purposes of signing court forms to say that a person has been to a MIAM before they submit certain applications to the court. There is additional training and CPD for child inclusive mediators, and we'll talk a little bit about child inclusive mediation later on. And you can find a mediator on the FMC website through the Find a Mediator search. The link is on the screen there, and also if you go to the FMC website, you'll be able to find it quite prominently. So our mediators are all very well trained and very well qualified. We're going to talk now about the benefits of mediation for families, and particularly of going to an FMC registered mediator for mediation. So mediation is less stressful than going to court. It saves the participants money as it's usually much cheaper than being represented in court. It helps participants put their child's interest first, and the mediator will help you focus on that. That's a part of the code of practice that we just talked about. Mediation helps participants keep control of their family's future. We've already talked about the participants making the decisions and not the mediator. It helps more participants move on quickly to the next stage of their life. And in fact, mediation can help immediately after separation or later on, as Marina just described, but it helps them progress to the next stage quicker than if you were to go to court. You can bring in the voice of the child to the mediation process, so you make sure that you hear the child if there are children in the family. Because the participants are making arrangements themselves and they're not imposed on them, they make arrangements that work. That leads to longer lasting outcomes. Mediation can also help participants have better, improved communication. The mediation process is one where they are either talking directly to each other or communicating through a mediator if you're doing shuttle mediation where participants are in different rooms or on different screens. But the mediator is helping them learn to communicate better and come up with a way of communicating for the future. It can also lead to better co-parenting and better cooperation. Some wider benefits of mediation. Mediation resolves issues so families don't need to go to court. It has a success rate in that respect of keeping families out of court in 69% of cases. That statistic comes from the Mediation Voucher Scheme, which is a government-funded scheme. There are fewer litigants in person. There are therefore shorter court waiting lists. There are savings to the public purse. There is reduced parental conflict and therefore wider educational, health and community benefits. We know from research that prolonged parental conflict can lead to physical and mental health challenges for children. It can lead to worse educational outcomes. It can lead to criminal and social consequences further down the line. So preventing that parental conflict is a very positive thing, and that's associated with better outcomes for children. So as well as the individual families, there are better outcomes for a society as a whole. I'm going to talk now a little bit more about the mediation process and something you may have heard of. In fact, I may have already referred to it as a MIAM. So the MIAM is the mediation information and assessment meeting. It's sometimes called a pre-mediation meeting or an intake meeting. It's a meeting that takes place before the mediation itself. Each participant has a one-to-one confidential meeting with a mediator. That is the MIAM. During that MIAM, the mediator explains the options for resolving issues. That's mediation. It's also other out-of-court options or going to court itself. The participants will tell the mediator their circumstances. The mediator is listening to the participant and assessing the suitability of mediation for that participant. The mediator will explain different models of mediation if that is appropriate. So the mediator may talk about shuttle mediation. They may talk about mediation in joint sessions when you're in a room together, online mediation, in-person mediation. And the mediator and the participant will explore next steps. If it's suitable to do so, the mediator will invite the other participant to a MIAM. If it's not safe and suitable, the invitation won't go to that second participant. Once a mediator has decided if mediation is possible, if it could be safe and suitable, it's then up to the participants to make a decision. Do they want to proceed to mediation? Do they not want to proceed to mediation? We referred earlier to the very important principle that's voluntary. It's therefore up to the participants to decide whether they go ahead. If it is safe and suitable, and if participants choose to and the mediator chooses to, then proceeds to a mediation session. Just to focus a little bit more on whether mediation is suitable and safe. We know that mediation is suitable and safe in many cases. In some cases, it might not be. The Domestic Abuse Commissioner has said where a survivor chooses to mediate and is safeguarded while doing so, mediation should be available. Any such service must be the choice of the survivor, and support throughout the process should be at the forefront of any approach and any mechanism. And the Family Mediation Council code of practice and standards are very much set up to support that process, to make sure that process, the mediation process, is supported for somebody who chooses to use it. So if you make a referral to a Family Mediation Council accredited mediator, the mediator will meet the potential participants separately, as we've just discussed, and they will assess whether mediation is safe and suitable. The initial assessment does take place at that MIAM or after the MIAM, but it's also ongoing through the mediation process. And so although if you have somebody who is it appears to be safe at the beginning of the mediation and something changes during the mediation, or the mediator picks up on something that hasn't been said or wasn't apparent earlier, the mediator has a duty to constantly assess whether the process is safe and suitable, and will stop the process if it doesn't continue to be so. So we've already said the mediation will only proceed if the case is safe and suitable and both potential participants want to proceed. And that is the case from the MIAM onwards and continuing throughout the mediation process. The mediator has a duty to signpost to let any participants in the MIAM or the mediation know of any appropriate support mechanisms. That might be a domestic abuse agency. It might be other forms of support that the person would require throughout the mediation process, or in resolving or dealing with the issues they're facing on family separation. There are also confidentiality exceptions to the code of practice. So the mediator has to keep everything in the MIAM and the mediation process confidential, unless there are safeguarding exceptions, for example, harm to a child, or other public policy considerations. Ramina, do you want to tell us a little bit about some cases in which, or how you go about assessing for safety and suitability and any issues that you've come across?
Of course. So I will, excuse me, I'm losing my voice. So I think you touched on something really key, which was about suitability and constantly assessing suitability. So at that first MIAM, when we are meeting our clients, any mediator, we are assessing whether the process is suitable for them And just to note that we do that at every single meeting. So every time we're with our clients, we are consistently thinking, is this the right process? And there might even be exchanges that happen outside of mediation that, again, as a mediator, you have to look at and think, is this the right process for you both still? So that's always there. But equally, it's just as important for the client to decide whether they feel it's suitable. So I had a case that just stayed with me for a long time. It was an initial MIAM, and she disclosed some quite serious coercive control, financial restrictions, monitoring of sort of communication, and she was really fearful. And I think this was a bit in particular that stayed with me. She was very fearful of repercussions. She kept asking if there was any way he would find out about the meeting, and she was desperate to mediate. She didn't feel that there were any other suitable options. And I think that's one great thing about mediation, actually, that not many other services necessarily do, but we talk a lot about the alternatives. We're not there just selling mediation. We are there to help clients. So we will try and obviously inform them about mediation, but we're also giving them information about other services. And in particular, with this case, she was adamant she wanted to mediate. Um, but she kept talking and trying to arrange with me when the mediation team could call her. She had a very specific block time where he wouldn't be monitoring anything she's doing. She'd take the dog for a walk. And she said, there's one thing you need to understand. There isn't a minute that's not accounted for. And I mean, obviously you're hearing that, and in a way, the way she was describing it was normal. It was she wasn't describing it like she felt there was a serious problem with it, but it was her norm, and obviously mediation was not suitable. And as the mediator, our responsibility at that point is to provide as much signposting, domestic abuse services, just to make sure that the client didn't feel they were just being left with no alternatives, and very clear feedback as to kind of what options there were realistically right for her were kind of given. So there are times when it's just not right for people for them to mediate. But equally, there are times, I heard not so long ago someone said, well, I thought if there was domestic abuse, then we just can't mediate. It wasn't a mediator. Thank God they said that. The truth is that's not true. We take a lot of our lead from, our clients. But obviously, there are times when, even if there is disclosure of particular behaviours, we can obviously support clients in using various other strategies like shuttle mediation, like slowing down the pace, like making sure there are very clear ground rules as to what's acceptable and what's not, and obviously clear signposting to legal advice and sort of lots of other information that might be useful. And I had one case in particular where very high emotional distress. She was complaining quite a bit about how there was a power imbalance and she wasn't very proficient in finances. Um, and so we were able to kind of, with the slowing of the pace, the shuttle mediation, she was able to understand what was expected of her, contribute, collaborate, and they reached an agreement on their financial settlement. So mediation can be really quite useful in those scenarios, even where there are times where, it might not be as straightforward. So there are just a couple of examples there, Ellen.
Thank you very much. Um, One thing I want to talk about very briefly, because it's very imminent from a Family Mediation Council perspective, is the domestic abuse assessment resource which we have been developing. So we know that training is critical. All FMC registered mediators are already all trained to assess whether mediation is safe and suitable, and they're required to prove they're competent in this before they become accredited. We've talked about assessment being required at MIAMS and on an ongoing basis. But because we know that consistency is so important and a structured approach that helps ensure key areas are not missed, the Family Mediation Standards Board has developed a resource to help mediators with this process, to ensure the sort of consistent approach is replicated across England and Wales. We developed that in consultation with domestic abuse advice agencies, and with mediators and with Domestic Abuse Commission's office. Um, so we are very proud of the resource that has been developed, and we're very pleased to be launching it next month. And training in the resource is going to be given to those mediators who are using it. So if anybody on the call's got any questions about that resource, we can take them at the end, or we're very happily speak to you afterwards about it. Right, moving on now. So what about legal advice or other options? Well, mediation participants are encouraged to take legal advice alongside mediation, particularly in financial or complex matters. Mediation participants are signposted by mediators to other sources of support that can be used alongside or instead of mediation. Romina just talked about other ways of resolving disputes, but also there are many services that can provide support alongside using mediation. And at the first meeting, so at that MIAM, mediators will discuss the different options for resolving it. So whether it's mediation, solicitor negotiation, etc., or whether or not actually bringing somebody into the mediation can support the mediation process. So whether it's other options outside of mediation, other options alongside mediation, there are lots of ways that families can be supported to resolve their disputes. Romina, do you have any examples of when legal advice or other options have been advised with your clients recently?
Sure. I think something we need to remember is good mediation doesn't try to do everything all the time. So there are examples where it makes sense for clients to take a particular point that they're struggling with and look at other options. So not too long ago, it was an all issues mediation. So that means we were looking at children arrangements, we were looking at property and finance. And the children arrangements, we were able to get through. They could agree a plan, holidays, Christmas, birthdays. It worked really well. Communication was a very civil, kind of structured. They had their Our Family Wizard parenting app, brilliant. There was just one particular point they just could not agree on, and it was pensions. So, of course, I signposted and said, look, perhaps you need to go and get some advice. But again, they were just stuck on a couple of points relating to pensions and their finances. And they ended up just taking that to as an alternative dispute resolution route. And via arbitration, they were able to kind of resolve it and reach an agreement on it whilst they continued mediation. So it's important to just remember there are times we can still be really successful with clients. We can still save them lots of money. We can still do a great job, but where they might need some outside assistance in particular matters, and that's okay. And like I said, you can obviously bring in other people as experts to help them, just guide them through understanding what is realistic. If this particular point gets taken out of mediation and they're arguing it in court, what's the reality of going to court on that particular point? So, yeah, I'd say that was one of the things that was almost refreshing because you forget you're always, you're mediating, you're trying to reach agreements for clients. And it was that reminder that actually, this village kind of how I try to structure it with my team is, we lean on each other. If they need solicitors at the right point, absolutely signpost them to solicitors. If they need an expert in a particular topic, signpost them. If they're struggling emotionally, signpost them, and provide that support. They're more likely to get through the process in a healthy way.
That's really helpful, thank you. And I think it again, the example you gave demonstrates the flexibility of the mediation process, and meeting the clients where they're at, and being able to bring in other things to help them meet their needs. So thank you. We're going to talk a little bit now about the voice of the child. So the voice of the child can be heard both directly and indirectly in mediation process. It says, obviously you can hear the voice of the child through parents in mediation, but that is somewhat filtered. The FMC Code of Practice does require FMC registered mediators to focus on the needs and the interests of the children at all times. And the mediators bring the child into the room by making their needs and their interests central to the process. Romina, can you describe how you might do that in a typical mediation?
So child inclusive mediation, there's a couple of things to just note, it's not always suitable for every parent for obvious reasons for us to even necessarily allow a child to be contacted and have their voice heard in mediation. But where it is suitable and you think this could make a real difference, it has an absolutely incredible, powerful impact. So I had a parent not so long ago say, I want to change the arrangements so that so I have the children on these days because it works better with my job. And as a mediator, my response was, well, can we look at this from looking at your child's week and their routine and school and the time that they spend with both of you and see how it works around them. So we are constantly trying to shift kind of that adult-centered approach to what the child what the child, needs are. And we do that because the reality is if they leave mediation as a process and they go off to family court, that's exactly what they'll be seeing there and they'll be expected to do there. So child inclusive mediation often as well really supports parents' communication. The amount of times parents like to just blame each other for one of the children not wanting to see them as much, or, one of the children being difficult when they're with one parent. And so actually, as a mediator, if you're trained like I am in child inclusive mediation, having that conversation with a child and it's very, very open, they're able to say whatever they feel comfortable saying, we're able to then bring that back to the parents and say, well, actually, it's not about you in particular. It's generally about what your child is feeling and thinking about these arrangements. The parents are then no longer pointing fingers. They can kind of work their plan, their arrangements specifically around what the child is saying that they need. So it helps them meet their children's needs. And obviously, as a result of that, their own needs are met as well because they're not going to be arguing as much. There isn't going to be as much conflict because they've worked on this and the steer has come from the child rather than two parents blaming one another. So it just creates a space for reflection and not reaction, which is what we're seeing all the time when parents are disagreeing on their children.
Thank you very much. So just to run through then a few of the technicalities really of the child inclusive mediation process that Ramina's been talking about. So child inclusive mediation is conducted by FMC accredited mediators who have additional specific training. It does enable the voices of the children to be heard. It's got recognised benefits to the health and well-being of the children and families more generally. Um, it does enable the parents to hear their child's honest views, and again, not the filtered perspective. Um, when the children are speaking to the mediator, they're speaking confidentially. So, as Romina described about the feedback to the parents, that will only be given if the child consents, and the parents will be well aware of this before the mediator speaks to the child. Um, once the feedback is given or not given, depending on what happens, the parents and not the children are making the decisions, and that's always very clear throughout the child inclusive mediation process to the parents and the children themselves. We're not asking children to take on responsibility of making decisions. We're asking the parents to consider the views of the children when the parents are making the decisions. Only verbal feedback can be given, and mediators cannot give reports to court. So there's no written report that can go. It's not instead of a Kafka's wishes and feelings report. It's a different process. Moving on now to talk a little bit about funding. So obviously in terms of actually coming to mediation, it needs to be practical, it needs to be accessible. Legal aid is available for family mediation. There are less family mediators who offer legal aid now than there used to be, but it is still available. You can search on the FMC website to find a legal aid mediator. Parents or ex-partners who aren't eligible for legal aid will have to pay for the first meeting. That's the MIAM. They generally cost between £100 and £200 each plus VAT. So it can be expensive if the parents or ex-partners don't have very much money. However, it remains cheaper than most of the alternatives. And up until the end of March this year, the Family Mediation Voucher Scheme is continuing. We hope that it may be continued beyond the end of March this year, but we're waiting on a government funding decision on that. The voucher scheme allows for up to £500 of non-means tested funding for mediation concerning arrangements for children. So this can be if you've only got arrangements for children, or it can be arrangements and children for children and finances, what we call an all issues mediation. But there do have to be arrangements for children to be considered there. The £500 is claimed through mediators who are accredited and registered to take part in the voucher scheme, and it's contribution towards the costs. For families who aren't eligible for legal aid, or where one participant is eligible for legal aid but the other is not, it can be significant. It can make a real difference. For those where neither is eligible for legal aid, it can really encourage them to try mediation without risk of losing anything. And it can cover all or most of the cost of the mediation itself, excluding the MIAM, in a lot of cases relating to children, especially where one party does have legal aid. So the Family Mediation Council, we have been calling for the voucher scheme to be extended. It keeps 69% of families who use it out of court. And we have also been calling for urgent legal aid reform, because we have lost a lot of legal aid mediators yet, because it's very difficult for mediators to sustain offering legal aid. But it is still available at the moment, and do look on the Family Mediation Council website for mediators who do still offer that. Romina, do you have any examples of cases where the voucher scheme and legal aid have been sort of offered together, or where these schemes have been able to help families who wouldn't otherwise be able to access mediation?
Yeah, lots, countless to be fair. So, in not so, very commonly we have clients wanting to access mediation, and one of their biggest concerns, of course, is funding. So, I had one client who was, qualified for legal aid, but the other party to the case did not. So that meant that both the initial meetings, the MIAMs, would be covered. The joint meeting was also covered, but any additional mediations would need to be funded by the other party for themselves. And the voucher scheme meant that they were able to top up. So essentially, it provides access to mediation, to a process that otherwise they wouldn't be able to access. And what we now know is from our research and the clients, I've been mediating nearly 10 years, is that where we can get clients, at what point they can enter mediation, it's really critical in the outcome. So that access to the voucher scheme, which is now available for parents that are trying to work through children arrangements, before the conflict gets too much for them, before things start to escalate and anxiety rise, and they start thinking, oh, maybe we need to go and speak to a solicitor. The voucher scheme has meant that we can get clients right at the beginning, explain what their options are, what the alternatives are. They feel a bit more in control, they're well informed, and this just allows the process to start early, before positions get hardened. And we know that generally means for a much smoother general arrangements that are finalized, rather than them having to then go to court. So it just means it's engagement, yeah, with the voucher scheme. The timing is super important. And of course, we know now with legal aid and kind of where things are, it's not as readily available. Less and less services are able to provide legal aid. So it's just meant that we've filled a gap for clients that otherwise wouldn't be able to do that. In fact, all my clients who are going through children arrangements are using the voucher scheme, if they're not obviously on legal aid. And the majority of them always say that if it wasn't for the voucher scheme, they wouldn't be accessing mediation, which is really comforting, because quite a lot of them go on to agree on their arrangements.
Thank you. And of course, for those clients who are eligible for legal aid, they are on the very lowest income. So even affording the cost of the MIAM would be very difficult.
Mm.
And if one party is eligible for legal aid does cover the cost of the MIAM and the first session for both parties, even if the second person doesn't qualify. So both schemes work very well together. Thank you. Right, so Romina has just said it's better if people can come to a mediation early, and that is absolutely true. The sooner parents and people can start talking to each other about their arrangements for the future, um, the better. But actually, you can refer to a mediator at any time, even if families have separated a long time ago, or even if they are quite a long way through their journey, if they've not tried mediation or they've tried it before and it hasn't worked so well, may be appropriate for them to come back again. Um, so, as a general rule, an early referral to a mediator can prevent disputes from becoming entrenched, but it doesn't prevent a referral at a later date. And there have been lots of mediations that have been very successful where people have been in conflict many times. There was a former mediator who told me that she had one particular family that had been to court many times and hadn't tried mediation. And I think it'd been to court over a course of a 15-year period with different children involved. And actually, the mediation with other support services were able to help those families keep away from court. So it can work even if participants are very entrenched. So don't be put off by two parents or ex-partners who don't speak to each other, or they're always arguing when they do speak. The mediator will do the an assessment and screening for domestic abuse when they come to a MIAM. They won't be in the same room together to start with, and quite often you will find the one partner or ex-partner says the other person will refuse mediation, but they are keen to go, and you'll find that actually both partners, both parents or both ex-partners are saying that, so they think it's the other person who will refuse. So if you have a family and one parent or ex-partner is saying one thing, um, saying the reason they won't go to mediation is because the other person won't, then don't be put off by that. Don't be put off by the fact that dispute's been long-standing, and don't be put off by worries about affordability, because there are schemes in place to assist families. Um, I know that we've got a number of the judiciary and magistrates on the call. Part 3 of the family procedurals does allow for cases to be adjourned for MIAMs to take place. And so we would encourage you, if you have a family in front of you and you think that out of court dispute resolution may assist them, then to refer to a MIAM. You can refer to a family mediator by looking up somebody on the FMC register. Please remember that anyone can call themselves a family mediator, even if they have had no training. But choosing a mediator from the FMC register guarantees that a mediator is appropriately trained and qualified. And so please do go to our website to look for a mediator. There's a postcode search from there, so you'll be able to find mediators who are local to you. That brings us to the end of the presentation. We are very happy to work with you as members of the local family justice boards to try and get mediator members on local family justice boards. We're very happy to arrange presentations or Q&As for your local family justice board. My contact details are on the screen now. There is a written guide to family mediation for the courts that you may find very useful. That's been endorsed by the President of the Family Division, and we developed that alongside the Family Justice Council. And you can find more information on our website, familymediationcouncil.org.uk. I'm going to stop the presentation now, and then we can have a little look at the questions and see whether you've got questions that we haven't answered. Please do use the Q&A function at the bottom of your screen to submit any questions that you've got. I'm not seeing any questions going in at the moment, but we'll just allow a few moments for questions to come through if needed. I mean, I think we must have answered everybody's questions because we don't have any
Um,
that are
I
coming
was
through.
about to say that. I was going to say, you were so good with your presentation. That might be one. I've just seen one pop up.
Right,
Oh,
a
here
couple
we
of
go.
questions are coming in now, so thank you. Right, so we've got one question. As a magistrate, we often find that parents won't consider mediation because they want the formality of court. How best to deal with this?
Mm.
Romina, how often do you have people in front of you that say, mediation's not for me, I want my day in court, or I want the formality of the court brings?
Yeah, it's not so much that they want, I mean, there are some that want the day in court for sure, but it is just they are working at times with individuals that change their minds, that use it as a kind of power play. So they want things to be formalized and legal. So what we say is, as mediators, we nothing of what we write is legally binding. So at that point, we can say, look, you can still mediate, you can still come up with your arrangements that you can both agree on. And then, of course, if you need it to be turned into a children arrangements order, then you can apply to court to do that. But that's, it's a very different process to kind of going in and being adversarial and, high conflict. That's kind of you've reached your agreement and the judge is signing off on it. So we just explained that you can actually do both.
Yeah, so your agreement can be made into a formal court order, and certainly in case of finances, it would
Mm.
you would usually expect it to be so. I think as well that we've seen reports of people who have been keen to go to court, but actually when they've got there, the magistrates or the courts have used their powers to adjourn something and refer to people to a MIAMS and reminded parents in particular that if the court is required to make a decision for their children, then it won't be necessarily be what either of the parents would make, and actually urging the parents to really step up and take responsibility for making their children's their decisions in relation to their children has helped because they've heard that message from the magistrate and from the judge, and that has then changed their approach if they've then gone back to mediation. Have you had parents who have been to court and have changed their attitude after they've heard messages like that from the judiciary?
Is that question to me?
Yes, sorry, yes, I was.
Yeah, okay. Yeah, absolutely. I've had clients go to court thinking it was going to be a certain way, and then coming back and saying, oh, gosh, it was awful. It's not what we expected. It felt like all the power in terms of what we wanted to agree was taking out of our hands. And I think it ties into one of the questions, actually, Helen, which someone asked, which was when parties are fixed in their perspectives, what can we do, basically? And exactly as you said, we as mediators will remind them, why are you here? If you're going to come to mediation to just argue, you've done that. You've done that for a long time. You're here to try something new. So there always got to be a mentality shift. And we need to be careful with the narrative of, it's cheaper and it's faster. Yes, it can be both those things. But boy, does it include you having to work a lot harder because you're turning up, you're trying to be reasonable in your approach, or you should be in mediation. And your mediator's there to facilitate you both making those agreements or suggestions or proposals. We don't have a magic wand. I say this all the time. If I did, I'd use it on myself. I'd use it on my voice right now so I could speak, but so clients need to understand if they just keep coming in their fixed positions and don't see any way of moving despite lots of suggestions, despite explaining what will happen in court. Even if you end up going through solicitors, they will fight your corner, and for the other party, that solicitor will fight their corner. If they still don't get it, then at that point, you have to also decide as a mediator, are they in the right process?
Thank you. That's helpful. Um, so we've got a question about it's saying what's the best way to manage a client who is a high conflict solicitor keen to use the court and misuse the court procedures. I'm not sure if that's from somebody from another um I guess another solicitor's point of view. So if you've got some if the other person is represented by a solicitor who seems to be keen to push things to court. I mean, as a mediator, you will see people in MIAMS and in the mediation process who are getting legal advice, all kinds of legal advice. And
Mm.
if one person has said, "Oh, my solicitor said this isn't working, we ought to be going to court," what would you do?
I would ask if they felt it wasn't working. Um, I get, I think there's something to be clear on, which is solicitors and mediators need to work together. It's really, really important. And I really strongly believe there's a place for mediation and there's a place for solicitors. And if we have a team approach, people are more likely to make it through with better outcomes. So predominantly, I'll ask the clients, what do you think about the process? How do you think it's going? You know, if you do come out of the process, has your solicitor explained to you what court looks like, how much it's going to cost? The amount of clients we talk to who can't give me a straight answer when I ask them, have you been given a rough estimate of court costs or how much it's going to cost to have your solicitor guide you through? No, I don't know. And so I try to empower them by saying, like anything else in life, you need to ask. You know, there's something about solicitors, and it's not all solicitors, but there's something where people do feel slightly concerned to ask, a bit more embarrassed. So in mediation, I always cover that. If you're getting legal advice, do you feel comfortable with the advice? Do you feel comfortable sharing with that solicitor? And signpost, always signpost to kind of solicitors that we've worked with that we know have very much more of a resolution mindset that would guide them, you know, through the right process.
Thank you very much. So that's really about kind of going back to the thing about making sure the client's informed and the client is making the decision. So not does the solicitor want to go to court, but do you want to go to court and have you got the information that you need about making that, but to make that decision?
Yeah.
Thank you. I think we've got one final question here, and this is about, I think it goes again to potential flexibility of the mediation process, although it would depend on those involved in mediation and who else you might want to bring in. But there's a question about if there are adult children who want to share their views on supporting the decision making for younger siblings, could that be accommodated, or how that be managed?
So I think it kind of touches on something you and I were talking about earlier on, actually, which is mediation being applicable to lots of different setups within families. So you might have grandparents, aunties and uncles, you know, there's lots of different people that make up a child's life. Our steer comes from our clients. So if our clients agree that they would like their adult child to also comment or be part of the mediation, it's just understanding what they're trying to achieve with that and how, of course, they'll be bound by the same confidentiality that two participants with their mediator are bound by. So we'd have to talk about confidentiality as well. And the two participants would also have to be consenting to the adult child because, of course, we are seeing that more and more that parents are still living with their children because they go off to uni and they come home, and it's really hard for you know, young people to kind of get out of the family home. So we are mediating more and more cases where parents are having to consider adult children. So it's just being clear with clients, what are you trying to achieve? And ultimately, you are both the people that are responsible for the decisions. It's a bit similar to, you know, children having a voice in mediation, absolutely, but they're not making the decision. So I think it's just about understanding how it would all fit together.
Thank you very much, Romina. That's really helpful. That actually brings me on very nicely just before we end to plug our webinar that's taking place tomorrow morning, which is about kinship care. So mediation, where children live with other family members. They are perhaps not the biological parents, but they may be caring, may become parents of children. So whether that's aunts, uncles, extended family members, or others. So we hope you can join us for that. I do apologise, it's got a little dark in my office since we started this webinar. I think we've answered all the questions in the chat. Thank you very much for coming today. Thank you very much, Romina, for joining us to answer all the questions. We hope you found it a very useful session. So thank you, everybody, and have a good evening.
Thank you.